Hi, everyone.
What page are we on in Crisis of Conscience?
We are on page 107.
He's talking here, and this is the last section of this chapter, on the way that the Watchtower dogma was defended for pragmatic reasons. It was not scriptural reason, it was the reasoning that somehow it will jeopardize the credibility of the governing body or the organization if we change our mind on these things. So he wants to expand on that thought here.
Mm-hmm. Listening to some of the arguments presented in the governing body sessions brought to mind the many cases that Jehovah's Witnesses had carried before the Supreme Court of the United States. Opposing lawyers had used arguments similar in many respects to those used on the governing body. Such lawyers stressed potential dangers. They claimed that there was a strong danger that door-to-door visitation might become a serious nuisance or a blind for thievery and other criminal activity, and that this justified placing restrictions on the witnesses' freedom to carry on this activity. They said that to allow the witnesses freedom to carry on their public activity or to give talks in parks in certain communities would lead to mob violence due to the adverse and hostile attitudes of the community as a whole, therefore that restrictions should be placed. They argued that to allow the witnesses to express their views on such subjects as saluting the flag, or their attitude toward worldly governments as being part of the devil's organization, could be detrimental to the interests of the larger community, could tend to create widespread disloyalty, hence be seditious. Restrictions were necessary.
The Supreme Court justices in many cases showed remarkable insight and clarity of mind in cutting through such arguments, demonstrating them to be specious. They did not agree that the rights of the individual or of a small unpopular minority could properly be curtailed just because the fear of possible or imagined danger or the claimed interests of the larger majority made this appear desirable. They held that before any rightful restriction could be applied limiting such freedoms, the danger must be more than a fear, something presumed to be likely to develop. It must be proven a clear and present danger, one actually existing. How many favorable decisions would the witnesses have received if the Supreme Court justices had not shown such judicious wisdom, such ability to see where the real issue lay, such concern for the individual? Their decisions were applauded in the Society's publications. Sadly, however, their high standards of judgment and their approach to emotionally charged issues often appeared to be on a higher level than that manifested in many governing body sessions. The expression of one Supreme Court justice in a particular witness case comes to mind. And he stated, and then we have a quote, but we don't have an attribution, but it's one of the justices in the Supreme Court.
The case is made difficult not because the principles of its decisions are obscure, but because the flag involved is our own. Nevertheless, we apply the limitations of the Constitution with no fear that freedom to be intelligently and spiritually diverse, or even contrary, will disintegrate the social organization. Freedom to differ is not limited to things that do not matter much. That would be a mere shadow of freedom. The test of its substance is the right to differ as to the things that touch the heart of the existing order. And that's the end of the quote. The confidence that the justice expressed in the existing social order and the freedoms it espoused seemed considerably greater than the confidence expressed by some governing body members in their fellow witnesses, and the effect their freedom of conscience, if exercised, could have on the existing theocratic order. If the Supreme Court justice had reasoned as some of the governing body members reasoned, the witnesses would likely have lost case after case.
And of course, this is exactly how totalitarian regimes reason, that the people must be under control for their own good. Court decisions are judged by history, the scriptural declaration that on a day certain to come, each Christian elder will render an account to the supreme judge regarding his dealings with and treatment of God's sheep, should surely give those exercising great authority among Christians a serious reason for weighing carefully what they do. Because of the power the organization exercises over its members through its decisions, and because of the enormous effect that these can have on people's lives, it seems proper here to review what I consider one of the greatest examples of inconsistency experienced in my 9 years on that body. It still seems difficult to believe that men who voice such strong concern for an uncompromising stand, keeping the organization clean, avoiding any taint of worldliness, could simultaneously gloss over a circumstance that can only be described as shocking. You may judge the appropriateness of that term by what follows, which leads him to the chapter 6, Double Standards, where he's discussing the policies as applied in Malawi and in Mexico during this very period. So we'll put in a link to what JW.org is not telling you about Judgment Day. And this is the first of 3 linked videos based on Acts chapter 17. And also we'll put in a link to the What JW.org is not telling you playlist, which is much more extensive than 3 videos. Check it out.
Okay.
See you next time.
Bye.